Good afternoon. Welcome on in to another episode of From Day One. Let's head to court for some fun this weekend.
Can we do this today, Your Honor? My health is in jeopardy right now.
What's that?
I have IBS, irritable bowel syndrome, and what's been going on is
Very stressful.
I'm bleeding inside, ma'am.
For a plea and potentially sentencing hearing all at the same time. Am I correct in that assumption then today,
Buckle up, people.
Attorney Muir?
Yes, Your Honor.
All right. Attorney Cass, Attorney Muir, who would state the terms for the record, please?
Thank you, Your Honor. In exchange for an acceptable plea to the amended charge of disorderly person, the people amended accordingly. Additionally, we do not object to a request for community service work in Monroe Jail.
Were you able to hear that, Attorney Muir?
I was, Your Honor.
Is that your understanding of the agreement?
Yes, Your Honor.
All right, Mr. Queisdorf, was that is that your understanding of the agreement?
Yes, it is, Your Honor.
And what is your full legal name, please?
James Dean Quistorf.
Quistorf. All right, Mr. Quistorf, I have in front of me an advice of rights and plea information form with your signature. Did you understand all of your rights contained in this form with your lawyer's help?
Yes, I do, Your Honor.
All right then. Concerning the matter, Mr. Quistorf, do you understand you have the absolute right to have a jury trial in your case, and in some instances you have a right to a trial by court? Are you aware of that?
I'm aware of that. Thank you, Your Honor. Yes.
All right. A motion to amend has been filed by the prosecuting attorney's office, changing the charge from aggravated indecent exposure to a charge of disorderly person, obscene conduct. The maximum penalty for that offense is up to 90 days in jail and or up to a $500 fine plus court costs are added on. The court shall order law enforcement to collect a DNA identification profiling sample. Additionally, there could be what we call collateral consequences, Mr. Quistorf. For example, you could have difficulty entering into a foreign country as a result of this conviction. Or if you're not a citizen of the United States, a conviction could result in removal or deportation from the United States, exclusion from admission to the United States, and or the denial of naturalization. Do you understand the nature then of this amended charge and the maximum penalty?
Yes, Your Honor, I do.
To the charge as amended, what is your plea?
I plead guilty, Your Honor.
All right.
Okay, so here we are. I seriously, I'll give a warning here. It's not that big of a deal, but this factual basis is not for the squeamish.
Then, Mr. Quistorf, before I accept your guilty plea, I want to make sure you understand the rights you're giving up by pleading guilty. Do you understand then by pleading guilty, there's not going to be a trial of any kind?
Yes, Your Honor, I do.
And do you understand that if you had chosen to have a trial instead of pleading guilty, you could have exercised each of the trial rights that are listed in this advice of rights form that you signed?
Yes, Your Honor.
And do you understand the consequence of pleading guilty is that you give up the right to exercise each of the trial rights listed in this
Yes, Your
form?
Honor.
Dave, Jack.
Do you understand the court is free to impose any sentence that the court feels is appropriate up to the maximum provided by law?
Yes, Your Honor.
Mr. Quistorf, understanding that and the other things I've been over here with you, does it remain your intention to plead guilty?
Yes, it is, Your Honor.
Are you presently on probation or parole to any court?
No, I'm not, Your Honor.
Outside of the terms placed on the record, has anybody promised you anything in order to get you to plead guilty?
No, they have not, Your Honor.
Has anybody forced you or coerced you in any way to get you to plead guilty?
No, Your Honor.
Has anybody told you the courts would simply be more lenient with you if you pled guilty?
No, Your Honor.
Are you pleading guilty freely, voluntarily, and understandingly?
Yes, I am, Your Honor.
You whore.
All right, then, Mr. Christoph, we're going to make out the elements of the amended offense for the record. The complaint indicates this occurred on or about September 7th of 2023 in Brighton Township, Dickinson County, State of Michigan. Do you agree with that?
Yes, Your Honor.
And concerning this amended offense of disorderly person, in your own words, then what did you do that constitutes this amended offense?
I went to the park and there was a man sitting on a bench and he asked me what I was looking for, and my response to him was to suck. And he said, well, let me make myself more comfortable here. I proceeded to get down on my knees in front of him, and he replied to me, oh, you want to suck? And I said, yeah, but this isn't going to work. And I proceeded to leave. However, I really believe that that conduct was disorderly and obscene, and I accept the charges against
Words that she said, or
Sure. I need for you to tell me what went on.
that I'm not on that whole shit. I'm not with that whole shit.
the charges.
All right, and was that in a public place here in Dickinson County?
Yes, it was.
It was
No, not near the falls. I don't remember the name.
hydraulic falls
Falls Park.
in Brighton Township?
Yes, ma'am.
All right. All right, so you're satisfied then that the words that you utilized and or the conduct was in fact indecent or obscene in a public place?
Yes, Your Honor.
I think that's a sufficient factual basis for the amended charge. Are the people satisfied?
Yes, Your Honor.
Are you, Attorney Muir?
Yes, Your Honor, thank you.
All right.
Oh, that's more than sufficient.
Is either counsel aware of any promises, threats, or inducements in order to get Mr. Quistorf to plead guilty that have not been placed on the record at this time? Attorney Muir?
No, Your Honor.
How about you, Ms. Cass?
No, Your Honor.
And does counsel believe the court's complied with the taking of pleas under Michigan Court Rule 6.610? Ms. Cass?
Yes, Your Honor.
Ms. Muir?
Yes, Your Honor.
All right, thank you. For the record, I will find then, Mr. Quistorf, that you have made out the elements of the amended offense. I will also find that your plea this afternoon has been made freely, voluntarily, and understandingly. I will accept your guilty plea and find you guilty of that amended offense. Concerning sentencing then, are you requesting to proceed directly to sentencing, Attorney Muir?
Yes, please, Your Honor, if we may. Mr. Quistorf is from California and has flown in for the hearing today. So if possible, that would be of great convenience to us.
All right, do you have an objection, Ms. Cass?
No, Your Honor.
All right, the pre-sentence report has already been completed by the probation department. Did you have a chance to review that with your client, Attorney Muir?
I did, Your Honor, thank you.
Is there anything of a factual nature that appears inaccurate to you?
No, Your Honor.
Is there anything you'd like to say then on behalf of Mr. Quistorf before the court imposes sentence?
I would, Your Honor. Mr. Quistorf is an engineer. He's got an interesting job as a satellite engineer in California. He has a military grade security clearance. He's 62 years old. He has absolutely no criminal history whatsoever. He is extremely embarrassed about this incident. He has immediately gotten himself into counseling, which he continues to attend. He has been forthright and honest, as far as he tells me, with his family and friends and coworkers, some of whom have submitted letters of support related to his character and background. He has renewed his faith, which is important to him, and with the church, he has been participating in neighborhood outreach for the homeless population, city cleanup, things of that nature, all of his own volition. He has received, the letters of support that he received were from people close to him who've known him for a long time that he has let know about this offense, including his brother, a coworker, a neighbor who's an attorney friend, and then his longtime family friend who's, both of his children are Mr. Quistorf's godchildren. So people who know him well, who are able to attest to his law-abidingness outside of this conduct, his remorse for this conduct, and his otherwise good acts in the community. I know that this was somewhat of a sting operation in the park and that others were also arrested on the same day. However, Mr. Quistorf did not have any contact with those people until he reached the jail where they were all lodged together. And I'm not sure if his case is...
Oh, good Lord. They had a sting operation. Then they all got arrested, and they take this crowd and put them in jail together. I don't even want to know.
Similar or dissimilar to those cases, but I think it's worth noting that he did not have any or attempt to touch the officer in any way, which is verified by the drone footage that was provided to us in discovery from the day of his arrest. He has been compliant on bond and has flown in from California for this hearing. He flew in actually a couple of days ago to make sure that there was no weather-related delays or anything like this. He reports that he doesn't use drugs or drink. He cares for his elderly mother in Wisconsin. He's prepared to pay the fines today. He'll probably be getting a refund, it looks like, from his bond money, but he has money prepared to pay any extra anyway. And I did discuss the possibility of him pleading no contest, but he was adamant that he would prefer to plead guilty because he wants to take full responsibility and indicate that to the court. So with that, Your Honor, I appreciate the offer of no jail time. I hope that the court is amenable to that. In addition, I would request that the court consider a sentence that does not include probation.
Oh yeah, this is a sting operation with drones in the park. I don't even want to know what the operation was called.
For all of the reasons stated. And if there are any terms or conditions, I would just note the social media condition. The only app that he uses that he feels is necessary, which seems reasonable, is LinkedIn for work. This arrest in this case has already had some ramifications on his current job, and he may be using LinkedIn for an employment search. So if the court is to include any social media restrictions.
I feel horrible for this guy, but it should. If he's got high clearance and he has access to things, he can be so easily compromised with this scenario. I'm sorry, but you know, security comes before this other stuff. I don't think he's a bad guy, but he's easily compromised. It's just the way I see it.
Restrictions, we would just ask for an exception that he be permitted to use LinkedIn. That's all. Thank you, Your Honor.
Thank you. Attorney Muir, I'm searching the file. I don't see any letters of support in here anywhere. Was there something I was supposed to review?
They were late coming last night, Your Honor. I did email them in, but I'm happy to summarize them for you. There was one from his brother, William Quistorf, who just reported that Mr. Quistorf has always been, a good brother to him. Let me pull it up here. He's truly family oriented, that he takes care of their mother in northern Wisconsin, that Mr. Quistorf, the defendant, is a Navy veteran who was honorably discharged, and that he has acknowledged this lapse in judgment as an aberration. The second letter was from a longtime family friend, John Vance, who is a 30-year veteran of law enforcement who has done a lot of detective work and attests that Mr. Quistorf is the godfather of both of their children and will also be the guardian if something were to happen to them, that Mr. Quistorf has always demonstrated a strong sense of honor and integrity and moral character. The third of the four letters is from the attorney friend whose name is Kelly Ray Wagoner, and she is the immediate next door neighbor of Mr. Quistorf for the past 20 years and a very close personal friend. And she talked about how they co-founded a neighborhood nonprofit organization several years ago that partnered with the local police and the Neighborhood Watch program to deter and reduce all categories of crime throughout the neighborhood, and that Mr. Quistorf was instrumental in working with the local police captain and leadership.
Did that extend to the parks, is my question.
To implement that, which resulted in a reduction in crime reports by about 50% in their neighborhood. And she says she's never known an individual so honest and committed to devoting their time and attention to helping the community. And she concludes, as an officer of the court in California, she would not ask these things or make this statement for anyone other than someone as truly wonderful as Mr. Quistorf. And then the last letter is from a coworker named Alexia Conrad, who says that she's been a work friend of Mr. Quistorf's for 30 years in the satellite industry, and that she works closely with him on a lot of projects. He's a hard worker. He is personally requested by foreign and domestic customers to handle really complex and difficult situations. She relies on him a lot for handling personnel situations, and that he's just a loving, attentive, and caring, empathetic person.
All right, thank you, counsel. I guess one of my only questions for you is that the recommendation is for a delay of sentence. I heard you say you were requesting a non-probationary period. Those two are incongruent. What are you asking for?
I would ask for a sentence of just fines and costs in this instance, Your Honor.
So he wants the disorderly person on his record?
What is I'm sorry, I must be I thought that only the jail time was suspended. Is this a diversion?
No, they were recommending a delay of sentence under 771.1, whereby if he completes his 9 months of probation successfully, this would not go on his permanent record.
Oh.
But if he doesn't,
I hope you know that this will go down on your permanent record.
We would take that, Your Honor. Sorry, I misunderstood that recommendation in the pre-sentence report.
And hell's yeah, let's do a diversion.
all right, all right. All right, I'm assuming so, but I'll have a chat. You get to go last. We're going to see if Ms. Cass wants to say anything. And that's only not because you're the least important, because you get to hear everything that goes on. That's what the rules say.
Thank you.
All right, go ahead, Ms. Cass.
Thank you.
Unless there's anything else, Attorney Muir.
No, that was it. Thank you very much, Your Honor.
All right, thank you.
Your Honor, when the complaints came in for this park, the Sheriff's Department here took it very seriously, and we can only hope that their thorough investigation has led to a deterrent effect of this issue. It does appear the defendant has taken this very seriously and did seem quite forthright with his admissions right now. So we ask the court to follow the recommendations by the probation department.
Thank you, Ms. Cass. All right, Mr. Quistorf, anything you'd like to add?
Yes. First, I'd like to apologize to the good people of the County of Dickinson County and the citizens here, and for this court and your bench for having to bring this trouble to in front of you. I'm truly remorseful for my behavior that day. I take it very seriously, and it's led to a life-altering event for me, and one for which I'm very grateful. For all good things come to the good for those who love the Lord, and that's really where my heart is. And I thank you for your consideration, Your Honor.
Thank you, Mr. Quistorf. And I think there's some tissues.
I'm good. Thank you.
Mr. Quistorf, we all make mistakes in life. Nobody's exempt from that. And you know what I usually tell people, I know you've not been here before, but how we measure ourselves is how we make up for our mistakes. We pick ourselves up, we brush ourselves off, we go on, we do better things, we learn from our mistakes. We try to pay good forward, and that's all we can do. Everybody makes mistakes. This was not an aggravated mistake, meaning, you know, you didn't take a piece of pipe and go swack somebody over the head, something of that nature. But this is not something that a community wants and, you know, wants going on out in the community.
It did involve a piece of pipe.
So law enforcement works swiftly here. A lot of people got in the same trouble. You're not the only one. I think you're the third one in this category I've seen today. So this is something we can't have going on in the community. This is something that doesn't belong in the public. If it's going to go on, it stays behind private doors where you have privacy. In regard to the matter, though, you are forthright. You seem very forthright. You seem like a responsible citizen. You've made it to 62 years of life without any brushes with the law. And I think the recommendations are appropriate. You should be given that opportunity to demonstrate that this is a one-time error in judgment that you will not likely repeat. So I will impose sentence under the general delay of sentence status, that's 771.1, whereby if you get through your term of probation successfully, this would not appear on your record as something that John Q. Public could access. Of course, police remain accessible, the prosecutor's office, the court. It stays available to the inside parties, but an employer, for example, could not open it up and try to find that, right?
Thank you, Your Honor.
So that's why I think a period of probation is appropriate, even though that it is one of these types of charges that is a presumptive non-probationary type of charge for the reasons one, that it was reduced from a felony to a misdemeanor, two, the nature of the misdemeanor, and three, the fact that I'm giving you an opportunity to keep this off your record. All those reasons make a probationary period appropriate. 9 months, there's a $300 oversight fee. Attached to your paperwork you'll get today is a notice regarding early discharge from probation. It explains what steps are necessary to achieve an early discharge, and it also explains what types of cases are exempt from early discharge. If you have any questions after reading it, you may speak with your probation officer or your lawyer about it.
Thank you, Your Honor.
And I am going to then impose fines and costs then on the disorderly person of $340, $75 to the crime fund fee, $50 to the justice system assessment fee. That's $765. I'll order that be paid in full today. Is that what your lawyer said?
Yes, sir.
All right. I'm going to order 10 days in jail with credit for the 1 day you've already served. 9 days will be suspended if you complete 18 days of community service work. You can talk to the probation department about how to achieve that when you go down there after court. In addition to the general terms of your probation, which are going to be listed up here, yours are going to be yellow and copy on the top. Checked will be the following. You are not to loiter in any public place. You are not to use, possess, or access social media accounts or apps, with the exception of LinkedIn, which is strictly for business purposes. You're not to be on the property of the Hydraulic Falls Park. Do you understand those conditions of your probation?
Yes, I do, Your Honor.
I'm going to read you your appeal rights, and it's on the back of the yellow sheet as well. An appeal to circuit court may be taken within 21 days from the date of your sentence, or 21 days from today. That's an appeal as of right, or as permitted under Michigan Court Rule